I see we're recording and people are coming into the Zoom room. It's great to see so many friendly faces, and thank you all for joining us. I also want to thank those of you, I'm sure many of our students here at Duke Law will be watching this recorded later. And so thank all of you in the future who watch this event and take part in it asynchronously. It's such a treat to have David Sklansky here joining us. This is kind of our Wilson Center book group. We've had a series of these events, which we call Novel Justice, thanks to Melissa Boughton for organizing this over more than a year now, and Marlene Dale, as always, for helping to organize these events and to coordinate logistics in the background. Our center at Duke works on a number of different criminal justice reform projects, including lots of work that's really, really relevant to this exciting new book, such as our work on juvenile sentencing reviews in North Carolina, studies of life without parole sentencing, and bail reform work. The topics in this book cannot be more pressing. I was just reading the New York Times after class this morning, seeing reports on the FBI's latest violent crime trend data from last year and what we should think of that and what it means. So we'd like to welcome David Sklansky, the Stanley Morrison Professor of Law at Stanford Law School. His past work has examined, for example, the role of police in democracy, which is another book that you should add in addition to Pattern of Violence to your reading list. Evidence Law, Fourth Amendment. I confess that I was the articles editor on a really fantastic Fourth Amendment article that Professor Sklansky wrote when I was a law student and I was on the Law Review. It was one of the first, pieces of legal scholarship that I read looking at criminal investigations and procedure. Lots of work on prosecutorial power and ethics, and he is a former prosecutor. Such a creative, lovely, and important book. You should all read it. We wish that he was here in person and that we could all be talking about it in person so that he could physically sign physical copies, and hopefully we'll be able to do that someday in the future. But what our plan was to have David talk a little bit about why he wanted to write this book. He's been working on it for some time. It was a treat for me to read some early chapters and see how they've changed in the final version. And so he'll talk a little bit about the motivation and give you a little bit of a big picture tour of the book. But then we'd really love for you to post questions in the chat. I have questions, but I'd much rather hear all of your questions. Please, start posting questions whenever they come to mind, and I'll also kind of keep a queue, and you can raise your hands as well. But either whether you like to post a chat or raise your hand, we'd love to call on you to have a conversation about this important and lovely piece of work. So I'll turn things over to you, David, for now, and then we'll all talk, hopefully.
Okay, thanks a lot, Brandon. Thanks for having me. Thank you, Melissa, for organizing this. And thanks to all of you for joining, those of you at Duke and those of you who are elsewhere. The starting point for this book, the reason I wrote it is that it began to seem to me that there were two big stories about criminal justice over the course of my career. Both of them were tragedies, and both of them had to do with ideas about violence. The two tragedies are mass incarceration and the collapse of police reform. So with regard to mass incarceration, most of you are familiar with the basic figures that we have an incarceration rate that is 5 to 10 times the rate of the countries that we would like to compare ourselves with, the United Kingdom, Canada, the countries in Western Europe. That didn't used to be true. When I graduated from law school in the 1980s, our incarceration rate was essentially the same as the incarceration rate in the United Kingdom and Western Europe and in Canada, and that rate had stayed constant for decades. But now we live in a very different world. The incarceration rate in the United States has dropped a little over the last decade, but we still incarcerate vastly more people than any country that we'd want to compare ourselves with. We have 5% of the world's population and 25% of the world's prisoners. And those prisoners are overwhelmingly people of color. People of color are 40% of the United States population and 70% of our prisoners. So that's one tragedy, the tragedy of mass incarceration. The other big story about criminal justice over the course of my career is the really breathtaking collapse of police reform. So it may be hard for some of the students who are here today to believe this, but 20 years ago, police reform was widely thought to be an unqualified success, not just by police executives, but by criminal justice scholars and by scholars of other legal fields. In fact, it was quite common 20 years ago for people to point to policing as exemplifying the kinds of reforms that we'd like to see in other fields of governance. Today, we're just in a completely different world. Police reform seems to so many people just to be a complete, utter failure. In fact, many people don't even think that it makes sense to even talk about police reform anymore, because the whole prospect of reforming this police seems to them a vain exercise. We should think about either abolishing the police or severely defunding it. So it seems to me, as I mentioned, that both of these stories have to do with violence. So with regard to mass incarceration, half of all prisoners in the United States are incarcerated for violent offenses or for offenses that are classified as violent, and that proportion is steadily rising. Many of these prisoners are serving long mandatory terms imposed under three strikes laws and similar legislation adopted in the 1980s and 1990s. So if we let out every prisoner in the United States who is serving time for a nonviolent offense, we could bring our incarceration rate down to the rate of countries like Russia, Cuba, Rwanda. If we want to look more like Western Europe or the United Kingdom or Canada, we have to radically revamp our treatment of crimes that we classify as violent. With regard to police reform, it also seems to me that the tragedy here has a lot to do with violence. And here the problem isn't making too much of violence. It's not paying enough attention to violence. So the reason why police reform was widely viewed as a great success in the 1990s and early 2000s was because of the achievements of the community policing movement, which I think were real. Nonetheless, that movement had some fatal flaws, and the biggest of them was that violence was off the radar screen for the people who constructed community policing and implemented it. So that meant, first of all, that police killings weren't a principal target of reformers. It also meant that the violence associated with everyday kinds of policing, like stop and frisk, were typically overlooked. In fact, police violence generally wasn't even called police violence. And in many places, it still isn't today. It's called the use of force or response to resistance. So I think that the reason why police reform got discredited was largely because of the failure to recognize and address the enormous problem of police violence, and in particular, police homicides of young people of color. So that's why I started on the book. I was interested in our ideas about violence and how to unpack them and how to make them better. It seemed to me, the more I thought about it, that there are three different kinds of ideas about violence that the law reflects and that are worth reconsidering. One set of ideas has to do with how significant violence is, whether violence marks off a completely different category or a category that should be treated very differently. So in criminal law today, we give violence a lot of significance. During the COVID pandemic, for example, in early 2000, when it became clear that jails and prisons were going to be vectors for the spread of the disease, many government officials, including the governor of my state, drew a sharp line and said that they were willing to consider early release for some prisoners, but not for any prisoners convicted of violent offenses. Violence didn't used to have this talismanic significance. Up until the middle of the 20th century, no one thought that you could cleanly divide crimes between crimes that were violent and nonviolent, and that doing so would tell you which crimes deserve the harshest penalties, and which offenders deserve the least sympathy. This is a modern invention. And it's not an invention that you see replicated in other fields. For example, you don't see it in policing. Well, I said that violence was off the radar screen for police reformers in the 1990s and the early 2000s, but it's also largely off the screen in criminal procedure. Those of you who have taken the criminal procedure class know that there are some special restrictions on the use of force by policing, by police officers, but for the most part, a seizure is a seizure. And what the police need in order to carry out a seizure doesn't really vary, depending on whether the police are ordering somebody to stop or grabbing them and throwing them against a wall. So that's one set of ideas that I think are worth reconsidering, and comparing how they surface in various fields of the law. The second has to do with the definition of violence. Because violence is so significant in modern criminal law, it becomes highly important what we classify as violent. And one reason why violence has become so significant in modern criminal law is because it sounds, when you talk about violent crime or talk about violent offenders, it sounds like you're referring to a natural category. But in fact, the legal category of violent crimes is highly artificial. All kinds of things are included that don't satisfy ordinary definitions of violence, and all kinds of things are excluded that do satisfy those definitions. So, for example, burglaries are generally treated as violent offenses, even if nobody is hurt or even at home when the house is broken into. Assaults are not treated generally as violent crimes because violent crimes usually means violent felony. And assaults are felonies only if they're aggravated by the presence of a deadly weapon or significant bodily harm. And those are categories that are as vague as they sound. Most assaults are not aggravated assaults, so most assaults don't count as the kind of violent crimes that our law treats harshly. The third kind of idea about violence that it seemed to me is worth questioning is legal ideas about the origins of violence. Sometimes we treat violence as though its origins are characterological, innate in the people who commit violent acts. Other times we treat violence as though it's situational. It just has to do with the situations in which people find themselves. In criminal law today, the tendency is very strong to treat violence as a matter of innate character. And that tendency has gotten stronger and stronger over the last half century. It's not nearly as strong in other areas of the law, for example, in the way we treat police. So the bottom line the arguments that I make in the book are that our ideas about violence warp criminal justice policies in multiple ways. Sometimes we pay too much attention to the difference between violent offenses and nonviolent offenses. Sometimes we don't give enough significance or pay enough attention to the difference in severity between, for example, violent police misconduct and other kinds of police misconduct. We often forget that violence is a constructed category and treat it as though it's a natural category. We are inconsistent in whether we treat violence as characterological or situational. In criminal law, we tend to be overconfident that it's a matter of innate character. And one result of that is that we ignore violence that doesn't seem to fit our preconceptions about what it looks like. Another consequence is that we ignore strategies for reducing violence that don't fit the idea that the problem of violence is a problem of violent individuals. So I've now essentially told you what the book argues, so you don't need to buy it. But there's lots more in the book. So please do buy it and read it.
That was great. And there was a lot more in the book. So please post questions in the chat or raise your hand if you just want to say it out loud as it's coming to you, whichever you prefer. It would be great if you did so. I have a few questions here too, but I would love to just wait maybe a minute and just see if some of you all would like to raise your hands. I don't want to discourage participation by jumping in myself, and I really want to hear some of the questions from the great folks we have here in our audience. Here we go. So Claudia, do you want to be on screen and ask it, or do you want me to read your question? Up to you.
Can you hear me? It's kind of loud. I'm in like
Yes.
Star Commons. Okay. I just wanted to ask, thank you for coming today and speaking with us. I'm just curious about like your former role as a prosecutor and how that kind of informed like patterns that you saw and how that kind of has shaped your scholarship, or if it has at all.
Yeah, that's a great question. I've wondered about that myself over the years, because I think it's shaped my scholarship in two different ways. One is by giving me certain blind spots, and the other is by encouraging me to re-examine my blind spots. So I was a prosecutor for 7 years, and I loved the job, as prosecutors tend to do. And I thought that I was doing good, as prosecutors tend to think. And I opposed lots of arguments blaming prosecutors for various ills in the criminal justice system. So I think one way in which being a prosecutor has influenced my scholarship is that for a while, the first 5 or 10 years that I wrote, I was not as critical of prosecutors as I should be. I've recently become more critical of prosecutors. On the other hand, I think it also had some more benign consequences on my scholarship. I dealt with law enforcement officers firsthand, and I dealt with a lot of them. I talked to victims, and I saw a lot of criminal defendants. And I think that experience impressed on me the complexity of all those groups. So it has made me resistant to essentialize ways of thinking about criminal defendants, and about law enforcement officers, and about victims. It's made me resistant to essentialized ways of thinking about judges and jurors and prosecutors and defense attorneys too. One feeling I had as a prosecutor that I've kept is that if we could find a way to take the worst 20% of prosecutors and make them as good as the second quintile of prosecutors, that would be an enormous advance. And I think the same thing is true about policing too, that if we could take the worst police officers and make them as good as, not the best police officers, but the second best police officers, that would be world shaking. So I'd say that the experience of being a prosecutor affected my scholarship in a whole range of ways.
Thanks again, Claudia. That's a great question. We have a second question from Jennifer. Would you like to ask it yourself too on the role of risk and violence?
Sure, yeah. I was just wondering about your thoughts related to the use of risk assessment instruments, particularly in decision making in all stages of criminal case processing these days. And do you think that there's any sort of relationship between the use of those instruments and risk assessment and the narrative that violence is sort of inherent to the individual?
Yeah, those are great questions. I'd love to hear what you think about that too. So my instinct is, first, with regard to the increased use of risk assessment, it seems to me a double-edged sword. On the one hand, for example, in the pretrial context, moving from cash bail to a risk assessment approach to pretrial release seems to me a good move, because for all the faults of risk assessment, it's better than locking people up because they're poor. On the other hand, I do think that there are dangers of risk assessment, and it can reinscribe racial prejudice in ways that are hard to ferret out. It can reinscribe the effects of racial discrimination and economic deprivation in ways that are hard to separate out. And I do think that we're overconfident sometimes about risk assessment, and sometimes not sensitive enough to the ways in which it can produce injustice. And I do think that those blind spots are a reflection in part of the kind of taken for granted assumption that we have that violence is a matter of individual disposition and not of the situations in which people find themselves.
I'd add there's even a critique of some of the risk assessment instruments themselves, which is implicit in your book, which is that to the extent that they're good at predicting whether someone commits again one of the offenses that is described in some way as violent, that raises this question of, well, if there's a violence flag in a risk assessment instrument, is it just saying that the person burglarized another unoccupied home? All right, how do we decide what generates a flag? And that raises all these hard normative questions that you explained.
Right. Yeah, there's a garbage in, garbage out problem with some of these algorithms.
Yeah, I attended a talk yesterday by Dr. Stephen Hart, who, of course, is one of the preeminent scholars in the area of risk assessment. And, he was talking about the fact that this definition of violence, which I think you stated at the beginning, is that it's elusive and it's, sort of changing depending on the circumstances, and maybe just Dr. Hart sort of implied that maybe it's meaningless, and the whole issue of applying group data to individuals. But I would push back a little bit on one of the comments you made in the pretrial context. While I'm all in favor of bail reform, I think that a similar and maybe even better outcome could be accomplished if we simply had a presumption of pretrial release, and without the necessity of using some sort of risk assessment instrument that it runs a high risk of being discriminatory or having a discriminatory impact on people of color and people who are poor.
I think you're completely right about that.
So we have a next question from Patrick Robinson. Do you want to jump in with audio and/or video, or I could read it if you?
Yeah, no, I don't mind. Great to see you, David. Great to see you, Brandon. Yeah, I'm curious, David, you started out with the comparison to other nations in terms of our incarceration rates. I'm just curious if in your explorations you've looked into the ways in which some of those other nations think of defined violence and how those definitions might relate to their legal systems, and then obviously eventually to their incarceration rates.
So I haven't done that systematically. I think it's a weakness of the book. It's a weakness of a lot of my scholarship that it's pretty US focused. And every time I start a new project, I think I want to make this comparative. And then at some point I feel like, it's too hard even to get my hands around the US stuff. So I don't follow through on that. I do have, though, some anecdotal impressions about how things differ in other countries. And I think that the most significant difference is not how they define violence, it's the importance that they give to violence. So for example, in the United Kingdom, they don't tend to talk about violent crime as a separate category. They talk about serious violence. So if there's a news report or if there's a government report, it won't be about addressing violent crime. It'll be addressing serious violence. And that sounds like it's not a big difference, but I actually think it's a huge difference because when you the phrase serious violence wears its subjectivity on its sleeve. Nobody thinks that serious violence is a natural category. Everybody understands that what counts as serious is a judgment call. And that was true as well of the categories that we used to use in this country to define the very worst offenses before we settled on violent crime. We used to, sometimes we would draw distinctions between felonies and misdemeanors. Sometimes we would draw distinctions between infamous crimes and other crimes. Sometimes we would draw distinctions between crimes of moral turpitude and other crimes. And as recently as the late 1950s, early 1960s, the term infamous crime, for example, was used just as often or more often in discussions of American criminal justice as the term violent crime. And the category of infamous crimes is notoriously problematic because it's so subjective. But one thing it has going for it is everybody pretty much always understood that whether we treated a crime as infamous or not was a judgment call. And so a lot of the damage done by the category of violent crime, I think, has to do with the fact that it sounds like it's natural. It sounds like it's not subjective. But in fact, it's highly subjective. And the more legal significance we give the category, the more artificial the category becomes. Because every time we say, well, if you're convicted of a violent crime, then you're ineligible for certain diversion programs or problem-solving courts, or you can be deported, or you can't vote, or whatever. As all of the consequences of being a violent criminal instead of just a criminal multiply, it creates more and more of an incentive for legislators who want to show that they're taking a problem really seriously to say, you know how serious this is? It's a kind of violence, and we need to say that. And that particular pathology, I don't think exists in most other countries.
That's a great point, a great thing to kind of reflect on. I'm curious, just as a quick follow-up, do you have a recommendation about the phrase, the semantic that should be used that appropriately distinguishes? I mean, it sounds like serious is maybe something that you spend a lot of time with. Is that the direction that you'd advocate for?
I think what I would advocate for is that we just avoid talking about violent crime as much as we can, and not just in legislation, but in ordinary everyday conversation, in op-eds. And I'll give you an example. So over the last year, 18 months, there's been a spike in homicide in many cities across the country. And depending on which data you look at, there may also be a spike in aggravated assaults. There may be, but that's hard to know, partly because the definition of what counts as an aggravated assault is subjective. But the way in which this problem is often discussed is the rise in violent crime. And that's true not just in the media, it's been true in some legislative work too. There are states and localities that have adopted new laws, new penalties, or new collateral consequences for people charged with or convicted of violent crimes over the last 18 months as a response to a rise in homicides. And so I think if we talked about that as a rise in homicides, or even more specifically as a rise in shootings, we'd be better off.
I suspect you wouldn't find it a useful clarification of what the governor did in Texas in the beginning of the pandemic, saying that you shouldn't have non-cash bond release of people who engage in physically violent acts. They added physically to violent, but
Yeah, I don't think that's really helpful, because I just think that all kinds of crimes that are treated as people will do the exact same maneuver. Like burglary gets classified as a violent crime, and for the same reasons it would get classified as physically violent. And by the way, I think when the governor talks about physical violence, it's not just that all things get read into that category that don't match the natural definition, but all kinds of things get read out of it too, like violence by police officers, violence against prisoners.
So next we have our Russell with both a question in the chat and a hand up. Thank you.
Sorry about the duplication there. David, thanks so much for doing this. Brandon, thanks so much for organizing. And I apologize that I've not yet read the book, so my question comes in part from that place. So I'm curious about whether the distinction between violent and nonviolent crimes, problematic though it may be, is at least more coherent if seen at a local level. And I think my intuition on that is one that typically I used to work with Ron Wright, so I'm always thinking about localism in criminal law. But also when I talk with my students now at the University of Alabama, we've been reading Emily Bazelon's Charged, and they think the idea that gun possession as a violent crime is just completely insane, right? And half of our students come from Alabama, the other half don't, but there's still a decent number of folks from the Southeast, and there's just this pretty strong sense amongst them that that's crazy to think of a mere possession law as a violent crime. So I wonder if there's something to, if we look at it more locally, whether it's a bit more coherent, though still problematic.
Well, I don't know. I mean, I think Emily talks about this in her book. The Brooklyn District Attorney's Office was criticized by Mayor de Blasio for diverting some gun possession cases. And de Blasio said, I'm all for diversion, but not in violent cases. So he's part, even at the local level, I think the category of violent crime is damaging discussions of criminal justice policy in New York. So I don't know. It doesn't feel to me that it's coherent at the local level. I mean, it is true that it's the definition of violent is more consistent at a local level because different jurisdictions define violence differently. So you avoid, there's one aspect of this problem that only surfaces when you compare jurisdictions. But I don't feel like that's the biggest problem. The fact that different jurisdictions define what counts as a violent offense differently is significant, I think, chiefly because it should flag the artificiality of the concept for us. That's the real problem here. The problem is that even at the local level, people treat the concept as though it's not a legal construct when it is. And they give it more significance than it deserves for that reason. If de Blasio had said, I'm all for diversion, but not in a case of any kid who has a gun. It wouldn't have been a crazy argument. Nobody would have said, oh, well, he's obviously out to lunch, but it wouldn't have had the same purchase. There's a reason why he went to the V word. And I feel like that damage gets done at the local level as well as when you compare jurisdictions. Does that make sense?
It does. Yeah, no, it makes perfect sense.
Well, speaking of the local level, our next questions are from Danny Spiegel, who works in our Durham District Attorney's Office.
Hi, Professor Sklansky. It's good to see you. I took your criminal law class in 2007, and I checked in with you a little bit before taking this position. So it's great to see you.
It's nice to see you again.
Professor, my first question was just about if it's possible to kind of delineate patterns between the states and making this distinction, or patterns federally. I think in our class we did a lot of model penal code, if I recall, but I know that that would not potentially help us here. I think it wouldn't. And I'm curious what patterns you see. And I'm just trying to think of specific examples where we actually are arguing that distinction. I was just arguing a few months ago in a difficult case where individual is not competent to proceed, but there was a question about whether they should be committed for some time for mental health treatment. And the question about whether the person had committed a violent crime had to be litigated. The law actually required us to figure that out. And it was not easy to do. The law didn't give us a lot of guidance, but the law said we had to figure out whether it was a violent crime or not. And then I was also just thinking, another example coming to mind was when officers use deadly force. It seems like the justification for that frequently does invoke some question about whether there's danger. And I think that's usually contemplating some kind of violent conduct. So I'm wondering about that.
Yeah, those are great questions. So, and this is what was, this gets back to what I was talking about in response to Russell's question. It's true that when you compare across jurisdictions, there are striking differences in the way that violence is defined and the consequences that are attached to it. Some states have a list of offenses that they say are violent. Other states just have a category of violence and ask courts to decide for themselves whether a crime counts. Some jurisdictions do both. The federal government does this notoriously. There are the Federal Criminal Code distinguishes in many places between there are many places in the criminal code where special consequences are created for crimes of violence. And crimes of violence are defined in a couple different places in the criminal code, the Federal Criminal Code, and almost all of those definitions identify certain offenses as violence. Those get sort of automatically brought into the category: burglary, arson, and then there's a broad category of that says other crimes that seem as violent. And the Supreme Court has struck down many of these statutes as unconstitutionally void for vagueness, void for vagueness, unconstitutionally vague. But many states have similar provisions. And then the states that do list what counts as violent, it varies. Some states treat larceny as violent. Louisiana treats purse snatching as violent. Many states treat possession of child pornography as violent. Other states don't. And then some states have different lists of what counts as violent crimes depending on which consequence of it being violent we're talking about, whether we're talking about the three strikes law or exclusion from diversion or early parole, for example. So there are wide variations. There are also variations in how police departments talk about violence, but the most common approach is to talk about a continuum of force. Some police departments have moved away from this because they don't even like calling it force. They call it response to resistance because force doesn't sound euphemistic enough. But more departments still use the phrase continuum of force. And the thing about the continuum, the idea is that as more force is needed, the police officers can use more force. Because it's a continuum, there's no sharp line. There's no point at which you say, okay, now we're talking about violence. There's just a continuum that starts with, pleasant conversation and ends with shooting somebody. And at each, the policies just say that how much force can be used depends on what the circumstances seem to require. So that's an approach that has some advantages. It's better than what some other departments do, which is not to have a use of force policy at all. But it's very different from what we do in the criminal context when we imagine that there's a sharp line that separates out the category of violence from the category of nonviolence. I'll mention one other big difference that you see when you look at the way police violence is handled and discussed, which is that whereas in the when we're talking about criminal law, there is a very heavy assumption, which has grown heavier over the last couple of decades, that the source of violence is people's innate character, that it's not a response to circumstances. And when we're talking about police violence, the discussion is much more bifurcated. On the one hand, supporters of the police tend to talk about police violence as though it's situationally created. It's a response to the situations in which officers find themselves. The critics of the police tend to talk about police violence as though it's characterological. It's either a reflection of the pathology of individual police officers or the pathology of overall the departments. And that bifurcated discussion leaves out a middle ground, which is worrying about the kinds of things that actually Brandon has written about with Beth Stoughton, the ways in which the actions that police take and the policies that police departments adopt can wind up creating situations that elicit police violence.
This is great. Next on the queue, we have Alex. Let's see if you're still here. Yes, you're still here. Do you want me to read your question or do you want to jump in? I can read it. He was asking, it's another comparative question, and so maybe somewhat outside the scope, but he was asking whether you have differences in crime compared to peer countries, whether that explains why we incarcerate more. And maybe I could add to his question, like, do we have more incidents of crimes that are defined as violent than other countries? Does that explain the unique American obsession with labeling crime as violent or not, or whether it's something else?
Yeah, so I don't think that crime rates overall are even a weak explanation for our high rates of incarceration, because there's no, there's no reason to think, there's no statistical support for the view that, for example, there's less crime in Rwanda or in the Soviet Union. I mean, there's no country in the world that has an incarceration rate as high as us. And I'm excluding countries that are like the Seychelles that have, but once you get up to once you're talking about a country of any reasonable size, there's no country in the world that has incarceration rates as high as ours. And our crime rates just are not that much higher than many other countries. Our rates of violence are different. Again, you can't argue that we have the highest rates of violence of any country in the world. There are many countries that are equally or more violent than the United States and that don't incarcerate as many people. It is true that when you compare the United States with the countries where we most want to compare ourselves to, which is Western Europe, Canada, Australia, maybe, we have much higher rates of certain kinds of violence. We don't seem to have higher rates of violence overall. What we have higher rates of are lethal violence, and in particular, lethal gun violence. that is an aspect of our country that you need to take into account when you're drawing comparisons with other countries. It does explain, or it can explain some of the much higher rates of police shootings in the United States than in other countries, but it can't explain all of them. So for example, we have about 100 people a year in the United States who are killed by the police, even though the police know that they don't have a gun. These are usually people in mental health distress waving knives. And there's no reason to think that that happens more often in the United States than in Europe or the United Kingdom. But when there are people in mental health distress with knives in the United Kingdom or Europe, those people almost never get killed by the police because the police use different tactics. They de-escalate. And it's worth pointing out that the police in the United States are almost never killed by somebody who doesn't have a gun.
Kind of related to that question and Russell's question earlier, like we certainly didn't have the Texas governor saying we have to do something about crimes in which someone has a gun.
Yeah.
Or just in general, like crimes with guns is not, I mean, there's certainly serious felon in possession offenses in this country. But on the level of violent crime, we don't have that kind of discussion about dealing with, or maybe de Blasio could have turned in that direction, right? To say that we need to deal with the problem of guns and there need to be a more activity with gun, not just gun possession crimes, even if guns are enhancers and lots of sentencing schemes and the like.
Yes. And our thinking about guns is also affected by some of the ideas about violence that I discuss in the book. The whole idea that it takes a good guy with a gun to stop a bad guy with a gun reflects a view about where gun violence comes from, and the nature of gun violence. Because so when de Blasio said, I'm against diversion of violent offenders, and he thought it was obvious that somebody who has a gun is a violent offender, that was consistent with the way the Supreme Court for decades has treated possession of a gun by somebody on the streets. That's why somebody possessing a gun, and that view that if the police have reason to think that somebody has a gun, they have reason to stop them and frisk them, was behind New York stop and frisk policy. It's part of the explanation for an unstated, often part of the reasoning in many Supreme Court stop and frisk cases, going back to Adams versus Williams. But it's a view that isn't really consistent with, it's not the view, obviously, that the governor of Texas has, and it's not the view that lots of gun rights advocates have. It's not the view that the Supreme Court tends to take in Second Amendment cases these days, where there's a different idea about what it means to have a gun, which is that as long as you're a good person, it's good for you to have a gun, and it's good for you to use the gun if you need to. So the ideas about what we think counts as violence and ideas about where we think violence comes from affect Second Amendment law, and I think warp it in some ways that parallel to the ways that it has warped criminal laws.
Next, we have a question from Kevin, one of our new postdocs here at Duke, who came to us from the University of Texas.
He says that he can't turn on his mic or camera.
Oh. Sorry, Kevin. So he asks whether you could discuss what the consequences might be in terms of net widening or net narrowing of tightening the definitions of violent crime. He says he's reminded of Sasha Nadapov's work on misdemeanors and how classifying offenses as fine-only offenses might be a way of narrowing the felony categories, but could have a net widening effect if police and prosecutors are more likely to charge people for the lower level offense. And so is this question of like, what if we're going to address this problem of over labeling of things as violent crime, what would be the possible consequences of relabeling?
So I will answer that, but can you give me 1 second? I need to let my dog out of my office. I'll be right back. Okay, Max, sorry about that.
The dog is free.
The dog has heard me talk about this book too much. I think that's a good point. It's worth worrying about. There's a more general problem about whether you want to kind of hang your hat on some criterion that seems faulty, or give it up, which might mean that you wind up sweeping in more people. And part of the reason why, that's part of why violence has become so significant in modern criminal law. It's not just that law and order conservatives have talked a lot about violence. It's that liberals, beginning in the 1980s, began to talk about violent crime as a way to separate out the crimes that they thought should be punished. So the Clinton strategy of dealing with the crime issue, both politically as well as a policy matter, was to try to wind down the war on drugs, but give no quarter to violent offenses. And that, it's hard to know, because we can't rewind history, whether the war on drugs would have gone on longer and been even more damaging if this strategy hadn't been used. But my own sense is that despite all the talk about we need to reserve harsh penalties for violent offenders, the war on drugs continued to be waged and continued to sweep all kinds of people into carceral facilities well into the 90s and the 2000s. And I think that the category of violence is so dangerous in the way that it begins to seem natural, and in the way that it can mask racial and class prejudices, that whatever benefit it could offer as a protection against net widening is outweighed. And I guess my sense is that it doesn't do much to reduce net widening. I think in some ways it does the opposite. And the reason I say that is that it seems so natural that once you say, well, we're talking about violent criminals, that gives license for all kinds of over-punitive approaches.
We have a hand up from Thea Johnson. Hi.
Hi. Well, this was super interesting, David. So good to see you.
Nice to see you.
And I have a 2-year-old home from daycare who's running around. So if you've talked about this and I missed it, I apologize. But Kevin's question was sort of making me think about the plea bargaining implications of all of this. And I'm wondering if in the book you talk at all about, the idea that we widen the law with the hope that prosecutors will just get it right on the charging end and, the negotiation end. And so that, is there any sense that violent crimes will broadly define them so that we, as legislatures, we seem tough on crime and we give prosecutors a lot of power, but that ultimately they'll use their gatekeeping role to really prosecute violent crime, and those crimes which, although they would be covered by the statutes themselves or meet the elements, will not ultimately get prosecuted as the violent crime. They'll get covered as one of the millions of other lower crimes that are available. Just thinking about sort of the shrinking of the definitions and the widening of the definitions and how they play a role in plea bargaining.
Yeah, I think there definitely is that sense. And this actually brings me back to the question Claudia asked earlier about how being a prosecutor affected my thinking. So this is something I became aware of when I was a prosecutor, because there's this statute, 18 U.S.C. 924C, which imposes a mandatory minimum consecutive sentence for people who use or carry a firearm during or in connection with a crime of violence. I know, because I was a federal prosecutor in the 1980s, that statute was charged quite freely. But I also know, because I looked into this when I was a prosecutor, that when the statute was initially passed, the Department of Justice distributed guidelines to prosecutors in the field, suggesting that the statute should be invoked quite sparingly, only in the most extreme circumstances. And then prosecutors should take care to make sure that the circumstances of the offense justified the additional sentence. But by the late 1980s and early 1990s, the Department of Justice took exactly the opposite stance, and prosecutors within the department argued that it was inappropriate for prosecutors to decide in their discretion that a particular offense shouldn't be charged, because that created disparities and wasn't an appropriate use of discretion. Instead, prosecutors should charge the highest, the offenses that carried the heaviest sentence, that were consistent with the facts of the case, which is to say that what could be proved in court. So I do think that there's one part of the story of the draconian sentences that we've adopted for violent offenses is a story about legislators saying, we want to give the prosecutors tools, and prosecutors saying that to the legislators. We need tools to investigate these cases. And then once the tools are given, they get overused. I mean, it's like police departments saying we need riot gear and armored vehicles just in case, but that once those weapons and equipment are on site, they have a tendency to be used, and to be used more and more prolifically as time goes on.
That's a great comparison. I hadn't thought of that, but yeah.
I was wondering if you could just end, some people probably have to leave at the end of the hour, but with one really big picture thought that I just thought would be wonderful if you could talk about for a minute before we close and clap and thank you. You know, you mentioned in your book, Steven Pinker's gigantic book on violence, and how in general violence, although he doesn't pause to really define it, has declined in societies all around the world. And certainly, however the FBI is defining violent crime, but there's been a stunning decline in violent crime over the past 2 decades, even if there was this really disturbing spike in shootings and murders last year. So we've experienced this steady and remarkable decline in violent crime, and yet we're obsessed with violence legally and in other ways to a degree that wasn't the case decades ago. Do you have like a final answer for us about why the increased obsession when violence has receded, even if it's hard to pin down?
Well, I think some of it is justifiable outrage at forms of violence that weren't acknowledged. I think that I think many people of color in the United States believe, with good reason, that they have been saying for decades that the police are killing their young people without justification. And the problem never received the consideration that it deserved. The problem of militarization of policing didn't receive the attention it deserved for decades either, because these were costs that were borne by people in the United States who didn't have platforms. So I think part of why there's renewed focus on violence, it has to do with outrage at that. Some of it has to do with genuine concern and justified concern about rising rates of homicide. Even though we're not back to where we were, there's still it was an alarming and tragic increase in homicides over the last 18 months, and it's there. We need to address that, and we need to treat it like a kind of national emergency. The fact that we're not as violent as people were in the 14th century is cold comfort for most of us. But I think too, I think there's another thing about our current moment, which is that we may be replaying in some ways a mistake that was made about rehabilitation in the 1970s and 1980s, when there was a grossly exaggerated sense that rehabilitation was an utter failure. The phrase was "nothing works," and that was what was treated as obviously true by all kinds of people, including lots of academics. I think we're in some danger. We've been doing some of that with regard to violence reduction methods and kinds of policing. And I think we have an exaggerated sense that nothing works in police reform today. And just as in the 1970s, the nothing works sentiment was an understandable reaction in some ways to outrage at abuses of the rehabilitative model, the current sense that police reform and violence reduction methods have been utter failures is in many ways an understandable and justifiable reaction to really horrible abuses of policing and horrible blind spots in the police reform agenda over the last several decades. But just as I think it was a mistake in the 1970s and 1980s to abandon the rehabilitative ideal entirely, I think it's a mistake today to abandon prison reform, police reform, and abandon efforts to make the criminal justice system in general more humane, more decent, and more effective and fair.
Perfect place to stop for the day. Thank you so much, everyone. Read the book, recommend it to your friends. And thank you so much to David for joining us.
Thank you, Brandon. This was really wonderful. I really enjoyed the conversation, and thank all of you for coming and for your terrific questions.